So for some time now, we have been looking at the law of tort. The law of tort, which is battery and assault. We have looked at it very careful, extensively. So, and then we look at how to juxtapose between the two. We look at battery, we look at, and then we juxtapose between the difference between battery and then assault. Of which we said that when you talk about tort of battery or battery in tort, it is committed by the intentional application of force, intentional application of force to another by direct means or through an unwelcome or physical contact, irrespective of whether there is an intent to harm or hostility is involved. So when you talk about assault of battery, we look at it from that perspective. So battery is an application of direct physical force to the claimant. The difference between battery and assault is that battery focuses on physical contact, but assault does not look at physical contact. You just look at the imminent or the pending apprehension. That is what assault looks at. But battery is application of direct physical force to the claimant. And then what Holt CJ said, Holt, S-O-L-T, Holt CJ said, in the early case of Cole versus Tenner, Cole, C-O-L-E versus Tenner, Tenner, T-U-R-N-E-R, T-U-R-N-E-R. He said that the least touching of another in anger is a battery. The least touching of another in anger is a battery. So that is what we look at in our previous discussion. Today we are going to look at unlawful arrest. We are going to look at unlawful arrest, false imprisonment, and malicious prosecution. Unlawful arrest, when a police officer arrests you in a manner that is against the 1992 Constitution, or if any other person who is even not a police arrests you in a manner which is against the 1992 Constitution, what you can do. And then what at all even constitute unlawful arrest. We look at that one, and then from there we look at false imprisonment, and then we end with malicious prosecution. We are going to have a very lengthy discussion. Make sure to grab your pen, take a sip of water, and be following the discussion carefully. So if you look at it, we are saying that these three things are what we are going to discuss in this lesson. So by the end of the lesson, you should be able to explain the term unlawful arrest and its elements. Then you should be able to explain the term false imprisonment and its elements, explain the term malicious prosecution and its elements, and then explain any defense to them, the defense to unlawful arrest, false imprisonment, malicious prosecution. So to begin with is the unlawful arrest. When we talk about unlawful arrest, the law on unlawful arrest are mostly in three sources. Number one is the 1992 Constitution of the Republic of Ghana. Number two is the Criminal Procedure Code 1960 at 30 as amended. Then number three is common law. So starting with the 1992 Constitution of the Republic of Ghana, 1992 Constitution, Criminal Procedure Code 1960 at 30 as amended, and then common law. So starting with the 1992 Constitution, we have Article 14, Article 15, and Article 16 that are talking about unlawful arrest, arresting someone in a way that is against the law of the land, unlawful arrest. What does Article 14 say? What does Article 15 say? What does Article 16 say? We are going to look at them one after the other. Article 14, Clause 1, it reads, every person shall be entitled to his personal liberty, and no person shall be deprived of his personal liberty except in the following cases and in accordance with the procedure permitted by law. A, in execution of a sentence or order of court. So it means that no person shall be entitled to, or say, it says that every person shall be entitled to his personal liberty. It means that for you have liberty, your personal liberty, you have your right to enjoy your personal liberty. And then no person shall be deprived of his, your personal liberty can never be deprived from you, except in the following cases, except that your liberty is challenged and your liberty is curtailed in so doing to execute a sentence or an order of a court. If your liberty is being disturbed because there is an execution of a sentence or order of a court, then that one is lawful, except contempt of court. If there is contempt, you can't say that I'm entitled to my personal liberty. You are not entitled to your personal liberty. Your personal liberty will be disturbed. Then for the purpose of bringing him or her before a court in execution of an order of a court, if we are bringing you before court for justice and law to prevail, then that one you can't say I'm entitled to my personal liberty. Your personal liberty shall be taken from you, and then your personal liberty shall be worried. The next one is a Criminal Procedure Code 1960 at 30 as amended. That is the next one. Criminal Procedure Code. That is what we are also going to analyze. When you look at section 71 to 81 of the Criminal Procedure Code, it reads that a warrant can be issued only by a judge upon a complaint made before him on oath. The warrant must state the offense. Madam Belinda, if you are there, please kindly read it for me.
Good evening, sir.
Good evening and welcome.
Thank you. Section 71 to 81 of the Criminal Procedures Code says that a warrant can be issued only by a judge upon a complaint made before him on oath. 2, a warrant must state the offense, the name and description of offender, and a direction to persons to apprehend the offender and bring him before a competent court.
So when you are under arrest by warrant, whether you like it or yes, your freedom or your right to personal liberty shall be disturbed. That one, whether you like it or yes, you will be arrested. So arresting with warrant, when you are arresting someone, one, per constitutional provision, it must be in execution of a sentence or order of court. 2, it must be by contempt. 3, it must be for the purpose of bringing him before a court in execution of an order of a court. We want to execute court's order or contempt or a sentence. Number 2, under the Criminal Procedure Code, whereby a warrant has been issued by a judge. That one too, you can go for the person. So we are looking at all this. Outside this, it is against the law. That is what you have to know. The reason for getting to know the procedures. This is about going against procedure. What you need to pass through in order to arrest someone, you refuse to pass through. These are taught against procedures. When you go against the procedure, you find yourself wanted. So let's read again from different the continuation of it.
Arrest with warrant. Warrants remain in force till executed or cancelled by the issuing court. Where a person is being arrested under warrant, the police can also search his premises and seize relevant materials.
Good. It means that when a warrant is being issued, it becomes active until it is being executed or it has been cancelled by the court that issued it. And then anyone holding a warrant, police or any security service holding a warrant, has the right to also search your premise. That is how it is. Let's go.
Arrest without warrant by private persons. A private person may arrest without warrant any person who in his presence commits the following offenses. A, any offense involving the use of force or violence. B, any offense where bodily harm is caused.
Good. So when we are talking about arrest without warrant by private person means the person is not a police or a security officer or whatsoever. But where the person is standing, what is going on is very wrong. And then the person wants to arrest the plaintiff and bring the plaintiff before the law. So we are saying that if that private person wants to arrest without warrant, then the issue upon which he is arresting must fall within these contemplations. Number one, whereby any offense committed is involving the use of a force or violence. If it involves the use of force or violence, then a private person can arrest. Number two is where any offense where the bodily harm is caused. You are standing there, someone has taken hammer and has hit someone's head with a hammer, and is also chasing the person with machete. And then you are body enough. You are macho. You have the muscles to arrest the person and to prevent the person from going to kill the other person. Then, as a private person, with that warrant, you can arrest. And the law will not catch you. The law will protect you. So arrest without warrant by private reasons. If it is not at the extreme instances of these points that I'm giving you, then any arrest will constitute unlawful arrest when a private person tries to do that. So let's go.
Arrest without warrant by private persons. Any offense in the nature of stealing or fraud. By B, any offense involving injury to public property. C, offenses involving injury to property owned or in the care of the arresting person.
Yes. Any offense in the nature of stealing or fraud. You have stolen something. We all have seen that you have stolen the thing. Yes, I'm not a police, but a private person, and still I can arrest you. I can arrest you. Once I have the strength, the capability, and then the ability to do so, I can arrest you. The next one is any offense involving injury to public property. Hey, possibly you are doing demonstration, and then you want to ban a particular hospital, and then we have Abodia people or machos, people with muscles around. They can decide not to allow you to do that. And if they arrest you, the law will protect them, because you want to cause injury to public property. You want to ban hospital, public hospital, the state-owned hospital. You want to ban it. No, if the person prevents you or arrests you and bring you before the law will never punish the person who arrested you. And then offenses involving injury to property owned. So if I am the one and then you are stealing my property or you are destroying my property, hey, I've seen you pouring petrol around my car, you want to burn it, and I've caught you. I can arrest you and bring you before the law. So that one also falls within the arrest without warrant by private persons. So a private person may arrest any person whom he reasonably suspects of having committed any of these offenses, provided that an offense of that nature has in fact been committed. So if you have committed these offenses, then the private person can stand in and make sure to arrest you, even though he is not a security personnel. However, the law will protect him. You should know this and understand. You should know this and understand. All right. So that is how it is. In the case of Walter versus Smith and Sons, that was where the principles were being brought to bear. Again, I must bring to your notice that private individuals also can arrest on suspicion. They can arrest on suspicion. However, not just any suspicion, but the suspicion must be on the basis of reasonableness. The suspicion must be reasonable, and the arrest must relate only to the 5 offenses above. The 5 offenses we have listed, and the offense must have actually been committed by the person who is arrested. The offense must have actually been committed. Offense must have actually been committed. So if the offense is not yet committed, then there is question there. If a private person arrests another who did not commit the suspected offense, he opens himself up to a suit for unlawful arrest. So if you arrest someone for an offense of which the person doesn't know anything about, then it means you're ready for a lawsuit. The person can file a lawsuit within the context of unlawful arrest. When we talk about arrest, unlawful arrest, we mostly think it is about the police people arresting you, sending you to police station, or someone arresting you, or something like that, arresting you in the context of sending you to police station. It does not necessarily mean that. If someone locks you up in a room and takes the key outside, it is called unlawful arrest. If a military person or a soldier, I remember when we were kids, we used to see that. Sometimes they will tell you, hey, come on, go down to the floor, go down to the floor, go down to the floor, go down to the floor. Do press up, 15 press up. Yes, press up. If you don't know it, you move, sleep on the floor. If you don't know and you make a step, you will see. If you don't know and you make a step, you will see. So they will be doing that. And then they will put you at one end. Again, they can also tell you, hey, sit here. If you don't know and you move, I will shoot you. All of them amounts to unlawful arrest. They might have not touched you, but they have detained you at one particular end of which you cannot move. It becomes unlawful arrest. Understand this once and for all. Unlawful arrest does not mean putting you into prison or putting you into cells. Unlawful arrest. So a police officer may arrest without warrant any person who commits an offense in his presence. If a police officer is there and then a person commits an offense, the police officer does not need a warrant before he arrests the person. Or if the person obstructs a police officer in the execution of his duty, the police officer wants to catch a criminal, or let me say a thief or an armed robber, and then you cross the police officer in order to prevent the officer from arresting the thief or the armed robber, then automatically the law will handle you. The police officer has the right to arrest you as a substitute and bring you before the law. Or when someone who is in prison or cells, who is in a lawful custody, is running away. A person who has been jailed into prison or a person who is in a lawful custody, when the person is running away, the police officer do not need a warrant to catch the person and bring the person back to the prisons. So when we look at all this one, we could see that we are within the scope of an arrest by a police officer. So we are saying that the police officer has in his possession any implement adapted for use in unlawful entry into building and has no reasonable excuse for owning it. So, all right. I hope you can hear me. So again, we are saying that the police officer also has the right to enter a place and then arrest a person. That one, it is not against the law. Yes. So that is what we are saying. If the police officer sees that or has a reasonable suspicion that a stolen item is with someone at somewhere, the police officer can go there and then make sure to retrieve the items. So for police officers, the offense need not to be committed in his presence, and there is no limit on the number of offenses they can arrest. They can arrest. So you should understand. You should know the difference between a police officer and a private person. A private person. A private person. All right. We are still on arrest by a police officer. And we are saying that the police officer may also arrest without warrant anyone he reasonably suspects of having committed an offense. Anyone he reasonably suspects of having committed an offense without a warrant. And then anyone that he thinks the person is about to commit an offense, or a person wanted by warrant of court. The person has been declared wanted, or a deserter from the enemy. The police officer can arrest such person. Can arrest such person. So understand this simple principle. We are still on the arrest by a police officer. When we talk about the arrest by a police officer, we are saying that having been concerned in any act committed outside Ghana, which if committed in Ghana would have been punishable as an offense, and for which he is under any enactment liable to be arrested and detained in Ghana. If someone commits an offense and run away and come to Ghana, that person could also be held liable. Yes. You can be arrested by a police officer. Again, for a police officer arrested on suspicion, the requirement is only reasonable suspicion. Remember, it is only reasonable suspicion. So looking at the case of Darlington versus Caffrey, 1962. Darlington versus Caffrey. I think you read it for us.
Arrest by a police officer. For police officers arresting on suspicion, the requirement is only reasonable suspicion. Darlington versus Caffrey, 1962. Whether a reasonable man assumed to know the law and possess of the information which in fact was possessed by the defendant would believe that there was reasonable and probable cause.
Reasonable man assumed to know the law. A person who is assumed to know the law and possess of the information which in fact was possessed by the defendant who believed that there was a reasonable and probable cause. Reasonable and probable cause. So you should understand it. We normally say red-handed. Something like red-handed, if you are being caught red-handed, then there is a reasonable suspicion. Or you're possessing an information. We know you're holding a gun that has been prescribed by only prescribed for only Ghana military service, or let me say armed force. And you're a civilian, you're holding that arm or that guns. What are you going to use them for? So we have to suspect you. Where did you get them? Quite. Arrest you and question you. All right. Continue reading.
How to arrest. Do not touch or confine the body of an offender unless he, the policeman, submits by word or deed. Asante versus the Republic. It was held on appeal that the police constable failed to put the appellant under lawful arrest by not informing him of the cause of arrest as required under the Criminal Procedure Act. And the police officer committed assault on the appellant by refusing to leave the spot where the appellant was and seizing his ignition keys, which was not an integral part of the process of arresting an appellant.
Very good. So according to the Criminal Procedure Act, if a police officer wants to arrest, according to the Criminal Procedure Act 1960, Act 30, if a police officer wants to arrest, the first thing to be done is to inform the person you are arresting what he or she has done. And then and not just what he or she has done, but in a language that he or she reasonably understands. In a language that the person understands. Let the person know the reason for the arrest in a very clear and succinct language of the plaintiff or the person that you are arresting. If not, it amounts to unlawful arrest. So in this case of Asante versus the Republic, the police failed. The police failed to put the appellant under lawful arrest by not informing him of the cause of the arrest as required under the Criminal Procedure Act. So if you arrest without informing the person that you are arresting in the language the person understands, emphasis, in the language the person understands what he or she has done, then at the moment you arrest the person also can arrest you. It is against the law. It can bring an action of unlawful arrest against you. Can bring an action of unlawful arrest against you. So you must know this. When you are defending your client, you must know all this. So let's go. Let's read.
How to arrest. When arresting by warrant an offender you sorry. When arresting by warrant an offender you believe to have entered the house, the occupier is required to afford reasonable facilities to search the place. If this fails, police can break in to effect arrest.
Very good. So finish with the other part before.
The person effecting the arrest may also break out to liberate himself. Persons arrested are to be subjected to no more restraint than necessary to prevent escape.
All right. So what we are trying to say is that, well, possibly there's an armed robber that policemen are chasing. That armed robber has entered your house. The law says that, or it is deemed to be that you, the occupier of the house, you are required to afford reasonable facilities. Open the door, let them come and check. You can lead them. Where else do you want to check? Do you want to check the gardens? Do you want to check the kitchen? Do you want to check here? Do you want to check here? Provide reasonable facilities to search the place. If you fail to provide reasonable facility, if you fail to do that, then the police has the right to break into your house, even if it is your room, to effect arrest. Armed robber has entered your house. We saw him entering here. Please, respectfully, we bring it to your notice. Help us, lead us through the corners that we suspect the armed robber is. If you can't do that, if persuasion fails, force must be applied. And then the person affecting the arrest may also break out to liberate himself. Persons arrested are to be subjected to no more restraint than necessary to prevent escape. When the person is arrested, you are not supposed to be harming the person. Like sometimes what they do, they'll be stoning the person with blocks. Some will be using hammer to hit their heads. No. Once you have arrested them, keep them in such a way that they will not escape again. Bring them before the law. So that is how it is. Now, what about, so we are saying that informing the offender before arrest. We are saying that, yes, you have to inform the offender before arrest. But my question is, what about flagrante delicto? Flagrante delicto, flagrante delicto. I think that is what is mostly referred to us as caught red-handed. The person is caught red-handed. You are saying that when I arrest the person, I should tell the person before arresting the person. But this one, we saw him just raping a sales girl. We saw him. We caught him red-handed. We caught him shooting the person. And you're saying we should tell the person what he or she has done again before arresting him or her. Abba, what do you mean by that? So it is a legal term used to indicate that a criminal has been caught in the act of committing an offense. Flagrante delicto. In English, it is called caught red-handed. Flagrante delicto, caught red-handed. In the case of DPP versus Hodgson, unless the offender is caught in flagrante delicto, the arrestee shall inform the offender of the cause of arrest. If acting under warrant, notify him and show it to him if he so desires. So apart from catching the person red-handed, that one you caught the person red-handed, so there's no need to tell him or her. Apart from that, any arrest, you must inform the offender what he or she has done before arresting the offender. And then if there is a warrant, if the offender requests for the warrant, show the warrant to the offender. Failure to do so also amounts to unlawful arrest. You should know all these things. If not, the person has committed an offense. But this little mistake can lead to the person, like the cancellation of the prosecution of the person. And then the unlawful arrest lies side to side with the criminal law. It lies side by side with criminal law. You see, criminal law is what basically focuses on arrest. And then if the person does it wrongly, then you sue the person in civil law, which is under unlawful arrest. You handle the person under civil law, which is law of tort. And then you're good to go. In the case of Yao versus Kobina, One Ghana Law Report, page 40. Let us look at the case of Asumani Bugembe versus AG, Attorney General. Yes, let's go. Read it fast.
Asumani Bugembe versus Attorney General. Plaintiff was injured while resisting arrest, and the police failed to inform him of the reason for his arrest. The court held...
No, before we even conclude, what do you think it is? It is against, right?
Yes, please.
Yeah, okay, so let's go.
The court held that the requirement that the person arrested be informed of the reason does not exist in the circumstances such. If the circumstances are such that he must know the general nature of the alleged offense, the person arrested cannot complain that he has not been supplied the information if he himself produces the situation, which makes it practical and possible to inform him.
Okay, are you getting this content? This content says that the person, though the police failed to inform the person, of which ideally you and I, we even concluded before looking at the holding. But the issue is, the case is in such a way that you yourself, you know why I'm catching you, or you are being arrested. You yourself, you know why the policeman is arresting you. The situation is so obvious in such a way that there is no need to even inform you again. You ought and should know, because you yourself, you were stealing, and then we caught. So it is caught red-handed. In the case of Asumani Bugembe versus Attorney General, whereby the fact of the case is such that the offender must know the general nature of the alleged offense, the reason why he's being caught or arrested. There is no need to even waste time to inform him or her again. We must know this. The offender should be decently searched and all things found on him placed in his custody. The offender must be taken with all reasonable dispatch to a police station or other place where the offender can be taken and be told without delay of the charge against him. He is then given reasonable facilities for obtaining legal advice, bail, and making arrangements for his defense. Yes. Then you make sure to let the plaintiff, you have access to legal advice. You have no right to prevent the offender or the accused from having legal advice. If you ask him or her a question and she says, please, I want to talk to my lawyer, leave him or leave her. Let the accused or the offender talks to his or her lawyer. Failure to comply means you have forced the person against the person's will. So that is how it is. And then any private person arresting without warrant shall without unnecessary delay hand over offender to a police officer or station. You are a private person, you have arrested someone based on the listed facts we have already discussed. At the moment you catch the person or arrest the person, quickly hand the person over to a police officer or a police station. And then a person taken into custody without warrant shall be realized not later than, shall be released not later than 48 hours unless he is earlier brought before a court. Unless he is earlier brought before a court. So when you catch an offender or when a person is being arrested, the person is not supposed to stay in the cells more than 48 hours. 48 hours. Unless the person has been brought to court and then the court has commanded so. So that is how it is. If not, then you cannot detain someone in cells like that. So far done, we have looked at the 1992 Constitution and the Criminal Procedure Code 1960 Act 30 as amended. So the last aspect on the unlawful arrest, as you could see it, is the common law. Because we said that the foundation of unlawful arrest lands on 1992 Constitution, Criminal Procedure Code, and the common law. So to begin with is the common law. Yes, please, read it for us.
Christie versus Linchenski provides the common law rules. Per Viscount Simmons held that if a police arrest without warrant upon reasonable suspicion of felony or of other crime of a sort which does not require a warrant, he must in ordinary circumstances inform the person of the true ground of arrest.
So common law is also of that view. When you arrest a person without a warrant or for reasonable suspicion, you are arresting a person because of reasonable suspicion. Yes, of a crime. Then you must let the person know the ground for his or her arrest. He is not entitled to keep the true ground to himself or give a reason which is not true. You can't give a reason which is not true, number one, and you can't say that, no, I won't tell you. In other words, a citizen is entitled to know on what charge or on suspicion of what crime he is seized. He is seized by the policeman, save for certain exemptions, is liable for false imprisonment. So unlawful arrest unlawful arrest. Unlawful arrest. You catch someone against the person's will. So when I began it, I told you that when the military people tells you to do this, do the press up, you see, the unlawful arrest sometimes move with the forced imprisonment. Forced imprisonment is about restraining the person or detaining the person. So when the military people tells you do press up, do this, do that, do that, if you leave, I'll shoot you. That one is forced imprisonment. The person has imprisoned you, But unlawful arrest is whereby a private person or a police officer detains you or arrests you or catches you without the due process. Due process, the process they're supposed to follow, they didn't follow. But the forced imprisonment is about detaining someone or restricting someone or confining someone and then depriving the person's freedom of movement or liberty to move. That one becomes forced imprisonment. That is how it is. So the requirement that the person arrested should be informed. I think the common law perspective, the requirement that the person arrested should be informed of the reason does not exist if the circumstances are such that he must know the general nature of the alleged offense for which he is detained. The requirement that he be informed does not mean the technical or precise language need to be used. Yes, please. Please kindly read here for us.
Common law rules. The matter is a matter of substance and turns on the elementary proposition that in this country, a person is prima facie, at first sight or based on the first impression, entitled to his freedom if he knows in substance the reason why it is claimed that his restraint should be imposed. The person arrested cannot complain that he has not been supplied with the above information as and when he should be if he himself produces the situation, which makes it practically impossible to inform him. And these principles apply to private persons' arrest too.
All right. I don't know whether we should read it for the second time. Let's read it for the second time. With all due respect, forgive me.
Okay. Common law rules. The matter is a matter of substance and turns on the elementary proposition that in this country, a person is prima facie, which means at first sight or based on the first impression, entitled to his freedom.
The matter is a matter of substance and turns on the elementary proposition that in this country, a person is prima facie at the first sight or based on the first impression. So the prima facie, that is what I'm explaining it for you so that you get to understand it. Entitled to his freedom. So everyone is entitled to his or her freedom. If he knows in substance the reason why it is claimed that his restraint should be imposed. The person arrested cannot complain that he has not been supplied with. So you yourself, you know why, the reason why you have been caught. You can't complain that you have not been supplied with the above information as and when he should be, if he himself produces the situation, which makes it practically impossible to inform him. And this principle applies to private person arrest too. What you are doing, you yourself, you know, we caught you when we were throwing stone at the public street bulb. You were breaking the bulb. We saw you. So if that be the case, you are not going to be permitted, or we are not going to provide you any additional information. I think that is how it is. So we are done with unlawful arrest. Anything that goes against this due process shall automatically amount to unlawful arrest. Shall automatically amount to unlawful arrest. Unlawful arrest. So that is how it is. unlawful arrest. When you're caught in that regard, you can also use the law to rebut it and then fight back your freedom and your right. That is unlawful arrest. Any question is welcomed. If you have any question for me, remember that unlawful arrest, it is all about arresting someone which is against the due process. Against the due process. You are arresting the person contrary to the due process as it has been provided by the 1992 Constitution of the Republic of Ghana, and as against the Criminal Procedure Code 1960 at 30, or the common law principles. And then we within all this scope, the 1992 Constitution, the Criminal Procedure Code, and the common law perspective, we divided them into two. One, by a police officer, and number two, by a private person. By a police officer, the law provides some basic rules and basic principles that you're supposed to follow in order to arrest someone lawfully. Failure to go by those due processes shall amount to unlawful arrest. By a private person, the law also provides the basic rules and the principles that has to be followed in order to arrest successfully. Failure to comply amounts to unlawful arrest. These are the two principles that have been established under unlawful arrest. I use the police people and then let me say the military personnel. Sometimes they say, hey, come here, kneel down, then they arrest you. That one is false imprisonment, of which we are come to discuss. Do press up. If you move, you will see. When you do this one, you will see. That fine, that one is false imprisonment, of which we are coming to discuss now. All your questions are welcomed. Thank you.